Estate planning myths debunked. You've been lied to. What if I told you that most families don't lose their wealth because of bad investments, but because of bad information? Maybe you've heard this before. You don't need an estate plan unless you're rich. Everything just goes to your spouse automatically. Or my personal favorite, I'll just grab a will online. It's the same thing. These myths are everywhere and they're dangerous because if you believe them, your family could be left with nothing but court battles, stress, and massive legal bills. The good news, these traps are completely avoidable if you know what to watch out for. Hi, I'm Jason Gray, an estate planning attorney here in Washington State. Over the years, I've seen too many smart, hardworking people fall into these traps simply because no one told them the truth. Today, I'm going to break down the 5 most common estate planning myths, the one I hear every week, and I'll show you exactly what to do instead. Let's jump in. Myth number 1, only the rich need estate plans. Let's bust this one wide open. People think estate planning is just for multimillionaires with mansions and yachts and all that stuff. But let me ask you this. Do you own a home? Do you have a 401k, a savings account, a car, kids? Congratulations, you have an estate. And if you don't have a plan in place, the state of Washington has one for you. It's called intestacy. This means that the government decides who gets what, not you. And here's the kicker, even modest estates, say a $600,000 home and a few retirement accounts can still get tied up in probate for months, even years. I once helped a family where the parents had no will or trust and their estate was worth just under $1 million. Sounds like a lot, but with funeral costs, taxes, and court fees, they lost over $60,000 to fees and red tape. You don't need to be rich, you just need to be prepared. Myth number 2, my spouse will automatically get everything. This is one of the most heartbreaking assumptions I see. People think that just because they're married, their spouse will automatically inherit everything. But here in Washington, that's not how it always works. Washington is a community property state, which means only assets acquired during the course of marriage are automatically presumed to be shared. Assets you have before the marriage, family inheritances, those don't always go to your spouse. They might go to your kids or even your parents or siblings. I had a client whose husband passed away suddenly with no will. She assumed everything would come to her, but instead she had to split his assets with his children from a prior marriage. She ended up having to sell the family cabin just to make things work. The worst part, that outcome was completely avoidable with the right legal plan. Myth number 3, DIY wills are good enough. This one is exploding lately thanks to online templates and TikTok advice, and I get it. A will template for $99 or $199 sounds way better than hiring a lawyer, but here's what they don't tell you. Estate law is very state specific, and those templates, they're generic, one size fits none. One of my clients used an online will generator. She thought she was covered, but when her father passed away, the will wasn't signed with the correct witness requirements under Washington law. The entire thing was thrown out in probate. That free will ended up costing the family over $35,000 in fees and months of emotional stress. Worse, it created conflict between siblings that still hasn't healed. Estate planning isn't just about having a document, it's about making sure it works when your family needs it most. Myth number 4, trusts always avoid taxes. Let's talk about one of the most dangerous oversimplifications out there. Yes, trusts can help you avoid probate, but that doesn't mean they magically erase all of your taxes. There are 2 types of taxes people confuse here. Estate taxes on the transfer of wealth after death, and then income taxes, especially from assets like retirement accounts or rental income inside of a trust. Some trusts trigger higher tax rates if not structured properly. Others, like revocable living trusts, don't protect you from estate taxes at all. So if your plan is just get a trust and I'm good, you could be in for a rude awakening, or your family could be. The right trust strategy is like a suit. It needs to be tailored to fit your specific assets, goals, and state laws. Myth number 5, I'm too young to worry about this. I hear this constantly from people in their 30s and 40s. I'm healthy, I don't have much, I'll deal with it later. But estate planning is not just about when you pass away, it's about maintaining control and providing protection. What happens if you get into an accident and you can't make medical decisions? What if you have young kids and something unexpected happens? Without documents like a power of attorney or guardian nomination, your family could end up in court battling over who's in charge. I had a young couple, both in their late 30s, who came in after a friend of theirs had a stroke. Couldn't speak or sign anything, had no documents, no power of attorney. His wife couldn't access his accounts, make decisions, or even refinance their home. It turned their lives upside down. Planning isn't being paranoid, it's just the responsible thing to do. We're offering a free 20-minute review session. It's not about scaring you, it's just about protecting the people that you love. Click the link below to book your call. And if you found this video helpful, YouTube thinks you'll love this one right here.